कोण नाही राहिलं ते डाउनलोड.
तरी तो फाईल फोटो आहे सर, फोटो टाकलेले बघा ग्रुपवरती.
हो, जेपीजी टाकलाय
ते
ना.
साधी फाईल आहे सर, मी आता बघा टाकली.
येस येस येस.
फोटो टाकलाय.
डॉक्टर प्रमोद जोगदेव हिरोदे सर, प्रोफेशनली समरी. सगळं रीड करू का सर?
हो येस सर.
हाँ हाँ. And occupied legally academic and administration with over 22 years of teaching experience at undergraduate and postgraduate level. Experience academic leader with 6 years as in charge principal, recognized PhD research guide, committed to institutional excellence, research promotion, academic governance, and quality assurance. 4 committees: academic leader, academic leadership, institutional administration, legal education, research supervision, uh, faculty development, quality assurance, higher educational governance, professional experience. In charge principal, Dr. Ambedkar College of Law, Chhatrapati Sambhajinagar, 6 year. Lead academic and administrative functions of the institution, supervise faculties, examinations, students' welfare, and institutional developments, ensure academics and regulatory compliance. Teaching experience: more than 22 years of teaching at PG and UG and PG level. Education: PhD, MPhil, LLM, BCom, NET qualified. Research profile: recognized PhD research guide, Dr. Babasaheb Ambedkar Marathwada University, 3 PhD scholars awarded, 1 international PhD scholar guided, 5 scholar currently pursuing PhD publication, author of 2 books, published more than 25 research paper in reputed journal, professional member research and recognition committee RRC, MGM Chhatrapati Sambhaji Nagar. Member Board of Studies Dr. Bamu. Member Board of Studies PAHS University Solapur. He highlights 22 plus years teaching experience, 6 years principal level administrations, PhD research guide, author, University Academy boy member. Thank you, sir.
Thank you. Am I audible?
Sir, completed.
Yes. Am I audible now?
Yes, sir.
Okay.
Good afternoon, sir.
At the outset, good afternoon to one and all.
Very good afternoon, sir.
Yes.
Good afternoon.
Yes. Thank
Good
you.
afternoon, sir.
Thank you so much. So today I will be dealing with the topic human rights and the Constitution of India. So friends, the concept of human rights will be dealt with in the first session, and the constitutional provision and the present scenario of the human rights in our country in the second part of this session. So as far as concept of human rights is concerned, it has been evolved with an objective that to curtail the authority and power of the state on the one hand, and second, to give or to accord human existence to the human being on the other hand. So therefore, so far as historical background of this concept is concerned, I would like to trace certain roots, historical roots, of course, historical resources, of course. So far as the human right denotes, means the definition is concerned, human right denotes all those rights which are inherent to our nature, without which we can't live as human being. Means unless and until the human rights are not given to human being would not be able to have the life as human. And therefore, whatever rights, whatever things are there, need to have its survival. These all are called as human rights. मानव अधिकार, ये जो चीजें हैं, एक दो तीन चार इस तरह से हम उनको कैलकुलेट नहीं कर सकते, बल्कि मनुष्य को मनुष्य मात्रा जैसा जीवन जीने के लिए जो चीजें की आवश्यकता है, वो चीजें प्राप्त करने के जो अधिकार है, उन सभी को ह्यूमन राइट्स, बोले तो मानव अधिकार ऐसा कहा जाता है. So handbook on human rights says that human rights are merely because he or she is human being. Means हम जब मनुष्य इन कैपेसिटी में जब आते हैं इस सृष्टि में, तो इस सृष्टि में मनुष्य मात्रा या मनुष्य इन कैपेसिटी में जीने के लिए जो चीजें चाहिए और उसके लिए जो जो कुछ हमको जरूरत है, वो सभी जरूरत बोले तो ह्यूमन राइट्स उसको कहा जाएगा. See, the human rights are equally, belong equally to all members of human family. Means एक को एक और दूसरे को दूसरा, इस तरह का ह्यूमन राइट्स का बंटवारा नहीं हो सकता. The human rights are inalienable. Means these are available to each and every human being in equal manner, irrespective of color, sex, place of birth, religion, caste, creed, nothing. ये कुछ भी मायने नहीं रखे. So this concept has developed through different stages in the history of human being. So therefore, the roots of human rights are traced into evolution of the Magna Carta, which was signed in 13th century by King John. Friends, you must be knowing that it is not the case of discrimination which rampantly happened in our country, namely India, but the discrimination was also found to be in existence in England as well, European countries as well. So there, but as compared to India, the European society has tried to eliminate the discriminatory practices far early than us. So what is Magna Carta? So Magna Carta was nothing but an assurance given by the King John, means state, what is the name? King John to the few families, those who were from Lord families. So the few provisions were applicable to the general public, and majority of the provisions of Magna Carta were exclusively made applicable to the royal families only. And therefore, though it is said that Magna Carta is the charter which has recognized basic human rights to the citizen by the king, but keep in mind these rights were restricted to the few families, those were belonging to royal families only. Therefore, the subsequent development which was taken place, that is none other than the petition of rights. In the year 1628, British Parliament sent the petition of right to King Charles as a statement of civil liberties, and it was based on 4 principles. Number 1, no taxes can be levied without consent of the Parliament. Number 2, no subject be imprisoned without cause shown. Number 3, no soldiers be quartered upon the citizenry. And number 4, martial law may not be used in peacetime. See, in their 1628, these were the statements of civil liberties sent by Parliament to the king, because in those days, almost powers were concentrated in the hands of King of Great Britain. Means the Parliament was posing to be at par with the king, and therefore they insisted that if at all the taxes are levied from the public, then it should be with the consent of the Parliament. So far as sending any person, any subject to the imprisonment, then the reasonable cause of his imprisonment, his arrest or her arrest, shall be shown to her or him. And third, that is, no soldiers shall be quartered upon the citizenry. Means military action cannot be taken and or imposed. And the military law, that is none other than the martial law, may not be used in the peacetime. Means in the martial law, what happened? Absolute powers are given to the military officers or military administration, and there is a every possibility to misuse it and violate or exploit the public at large. The public at large. And therefore, the petition of right was said. These all 4 statement of civil, the statement of continue the all 4 principles contained by the civil liberties is called as the petition of right. Friends, in the history, in the history of independence of the country, one must look at the independence of United States of America. The United States of America issued the Declaration of Independence on 7th July 1776, and it contained or it traced 2 things or 2 themes. Number 1, individual rights, and number 2, right of reservation. Individual right and right of reservation. Earlier to this, in Great Britain, there was a concept, admitted concept, that king can do no wrong. म्हणजे हे जे काही इव्होल्युशन सुरू आहे ह्युमन राईट्सची, याच्या वेळेस एक कन्सेप्ट, एक संकल्पना तिथं रुजल्या गेलेली होती ग्रेट ब्रिटनमध्ये. ती अशी होती की किंग कॅन डू नो रॉंग. राजा कुठल्याही प्रकारचं जे काही कृत्य करत असेल तर ते कृत्य चुकीचं कृत्य नाही, अपकृत्य नाही. And therefore, absolute immunity was given by law to the king from all activities. जे काही कृत्य राजा करेल, किंग करेल, त्यापासून त्याला पूर्णतः मुक्तता कायद्याप्रमाणे देण्यात आलेली होती. पण नंतरच्या काळामध्ये जसं आता तुम्हाला सांगितलं मॅग्ना कार्टा आणि बिल ऑफ राईट्स, तसंच नंतर युनायटेड स्टेट्स डिक्लेरेशन ऑफ इंडिपेंडन्स मध्ये सुद्धा काही गोष्टी आल्या. त्याचा पहिला थीम होती ती इंडिव्हिज्युअल राईट्स, म्हणजे व्यक्तिगत अधिकार अँड राईट्स ऑफ रिझर्वेशन. सो द बिल ऑफ राईट्स which was placed on 15th December 1791, means after declaration of independence to the USA, it protects basic freedoms of United States citizens and limiting thereby the powers of federal governments and protects rights of citizens, residents, visitors in United States. बिल ऑफ राईट्स आलं आणि हे बिल ऑफ राईट्स कशानंतर आलं? अमेरिकेचं इंडिपेंडंट डिक्लेअर केल्याच्या नंतर. तर 1791 में बिल ऑफ राइट्स लाया गया. इसमें दो चीजें, एक फेडरल गवर्नमेंट की जो पावर्स है उसको लिमिट में रखना, और दूसरी जो है तो सिटीजन्स को राइट्स, रेसिडेंट्स को राइट्स और विजिटर्स को राइट्स, उनका जो संरक्षण है उसको प्रदान करना. So these become very important, and in addition to these rights, the Bill of Rights protected the freedom of speech, freedom of religion, a right to keep and bear arms, freedom of assembly, freedom of petitions. So these rights were protected by the Bill of Rights 1791. तो पहला अधिकार जो है तो यह है फ्रीडम ऑफ स्पीच, बात करने का अधिकार, अभिव्यक्ति स्वातंत्र. फ्रीडम ऑफ स्पीच, अभिव्यक्ति स्वातंत्र मीन्स जो भी कुछ आपके दिल में आया है और आप बयां करना चाहते हो, और that ought to be for the larger interest of the public. It should not be detrimental to the interest of the public. It should not be detriment to the peace and tranquility of the society. Means provocative speech which would be disturbing to the peace and tranquility of the society. इस तरह से फ्रीडम ऑफ स्पीच रिकॉग्नाइज किया गया. फ्रीडम ऑफ रिलीजन, जो रिलीजन आपको पसंद है उसको उसके ऊपर फेथ रखना, ये वो आपका अधिकार है. राइट टू कीप एंड बियर आर्म्स, कुछ लोग खुद के रक्षा करने के लिए और कुछ लोग एक अपने धर्म का, अपने मजहब का पहराव बोल के आर्म्स परिधान करते हैं, रखते हैं, वो अलाउ किया गया. फ्रीडम ऑफ असेंबली, इकट्ठा होना, एसोसिएशन गठित करना. फॉर व्हाट? फॉर प्रोटेक्शन ऑफ द कलेक्टिव इंटरेस्ट, फॉर द प्रोटेक्शन ऑफ द कलेक्टिव इंटरेस्ट. ये सब चीजें के लिए यहाँ पे फ्रीडम दिया गया. लेकिन इसका मतलब यह नहीं, इट डजंट मीन दैट फ्रीडम ऑफ असेंबली टू बी एंजॉयड टू create hue and cry. to create deterrent in the minds of other people. Freedom of assembly, it doesn't mean that to assemble to cause disturbance to the public peace and tranquility. No. If these are being the objective or intentions behind coming together, that will be amounting to criminal activity. That would be amounting to criminal activity. And when it is a criminal activity, you will be liable to be prosecuted and punished. Freedom of petitions means if at all your rights have been violated, infringed by the state or by non-state entities, then you have been given the freedom to go to the court of law, knock the door of the court of law, and get your rights protected. Means only giving right is not sufficient unless and until they are being protected by way of creating independent impartial mechanism. Independent and impartial mechanism vis-a-vis court system. So these were the basic rights given by the Bill of Rights. Bill of Rights prohibits unreasonable search, seizure, compelled self-incrimination, unusual punishment, prohibits double jeopardy and speedy trial. Friends, these all things are available in the law which are in application today in our country, including the Constitution of India. So far as the prohibition of unreasonable search is concerned, unreasonable seizure is concerned, it is being given to protect your right to privacy. Your right to privacy. मतलब पुलिस हो या कोई गवर्नमेंट एजेंसी हो, आपके घर का और आपके बॉडी का सर्च अगर करना चाहती है वो रिजनेबल तरीका होना चाहिए। आपका घर का अगर सर्च करना है तो आपकी परमिशन पहले लो, अगर आप परमिशन नहीं देते तो कोर्ट में जाके परमिशन लो और बताओ कि व्हाई conducting of search is important. If you permit or court permits, then only conducting of search is permissible or possible or it is done. If not, then no police authority or government authority or even private individual can conduct search. Another point is seizure. Seizure means ये करना, बरामद करना. क्या? If any impermissible thing is being possessed or stored by an individual, that is to be seized. Usually, seizure is conducted by the police in the course of investigation to collect the to collect the weapons used by an accused in commission of an offense. Second, conduct seizure of the clothes which accused has put on his body while commission of an offense. Or seizure is conducted to seize the stolen property, which is the subject matter of the offense of theft, dacoity, robbery, and extortion. So in these cases, seizure is conducted or it made permissible. If not, कोई भी आएगा और बोलेगा कि ये चोरी का माल है और मैं जो है तो इसको सीज कर रहा हूं, नहीं चलेगा, इस तरह से नहीं चलेगा. Bill of Rights prohibits it. Compelled self-incrimination, friends. This right has been aptly given in our Constitution, most particularly Article 20, Clause 3 of the Constitution of India, that no one shall be compelled to be a witness against himself. No one shall be compelled to be a witness against himself. मतलब जिनके ऊपर इल्जाम लगाए गए हैं, एलिगेशन लगाए गए, जिसको हम रिवीलिंग लैंग्वेज में, यूजुअल लैंग्वेज में जो तो एक्यूज बोलते हैं, अपराधी बोलते हैं, वो अपराधी को ऐसी हालत पुलिसों ने नहीं निर्माण करना कि वो खुद उसके ऊपर जो भी कुछ इल्जाम लगाए गए हैं वो एक्सेप्ट करे, कन्फेस करे. Why? Because it is against the concept of fair trial. It is against concept of fair trial. We have accepted the concept of free and fair trial. In India, we accepted the accusatorial trial. In accusatorial trial, there are certain principles of criminal justice. One is that the accusation of the accused shall be proved by the prosecution. And number two, the prosecution should prove the guilt of the accused by way of adducing cogent and corroborative evidence beyond all reasonable doubts. Beyond all reasonable doubts. Then only the prosecution side is believed in by the court of law and the accused person is brought to the door of guilt and the accused is punished, convicted. But when the accused person is compelled by police machinery, investigation machinery, to incriminate means to accept the guilt, accept the allegations which have been leveled against him. त्यांनी जे काही गुन्हा केल्याचं त्याला म्हणलं गेलेलं आहे ते त्याला असं कंपेअर करून त्यांनी ते मान्य केलं पाहिजे की मी केलेलं आहे.
कपिल यार उसका क्या फोन चलता है, ये मेरे को क्यों फोन कर रहा है? तो बोला कि है ना मैडम मैं है ना बाहर खड़ा हूँ और नहीं मैं है ना लाइब्रेरी के अंदर हूँ.
अगर ऐसा होता है तो फेयर ट्रायल के खिलाफ है. दिस इज नॉट परमिशन. In our constitution, this right has been elaborately explained, which the Article 20 Clause 3 I have referred to aptly. There are 8 numbers of judgment of the Supreme Court, and most popular judgment I would like to quote here is that is pertaining to the narco-analysis test, Murugesan versus State of Tamil Nadu. In this case, the Supreme Court of India has said that to ask or to compel an accused person to undergo the narco-analysis test is violation of the principle of protection against self-incrimination. And if the statement is given by an accused person while undergoing the narco-analysis test, would not be taken into consideration as an evidence. So, friends, keep in mind that the protection against self-incrimination, the basic human rights which was given by Bill of Rights. Another point is unusual punishment. When the accused person has been proved to have guilty for commission of an offense made punishable by law, then that person is to be punished. But punishment should be as per the provisions of law. एखादे अपराध के लिए अगर 7 साल की सजा कानून में दी गई है तो 7 साल तक की सजा कोर्ट ने देना चाहिए। 10 साल की सजा लाइफ इम्प्रिजनमेंट कोर्ट ने नहीं देना चाहिए। या जो कानून पहले मौजूद था और अभी जो तो रिपीट किया गया, उस कानून के प्रावधान लगा करके पनिशमेंट नहीं देना चाहिए। So punishment is to be given provided in accordance with the provisions of law. It should be in accordance with the provisions of law. And another prohibition which was imposed by Bill of Rights was double jeopardy. Article this provision is reproduced in the provision of our Constitution. Article 20 clause 3 and Article 20 clause 2 provides that no one shall be punished twice for the same offense. For the same offense. एक बार एक अपराधी को सजा सुनाने के बाद वही सेम अपराध करने के लिए दोबारा उसको सजा नहीं दे सकते, उसको सजा नहीं दे सकते। एक बार सजा हो गई, मैटर एंड्स फाइनली, मैटर एंड्स फाइनली, and if it is done, then it is violation of his fundamental right vis-a-vis basic human rights. And speedy trial. Last is speedy trial. Prohibition of speedy trial. Why? Because there is a settled mechanism. There is a settled mechanism to prove the guilt of the accused person. In a legal language, in a stricter sense, it is called as trial. So whatever steps and stages are there given by law, each and every trial must go through all these stages and steps. If in speedy manner the matter is disposed of, then it is violation of the human rights. Why? Because there should be fair trial, not speedy trial. So in this way, the Bill of Rights has put certain restrictions, certain prohibitions on the state. It also restricts state to make law depriving life, liberty, property without due process of law. Friends, the wording due process of law is extremely important. Means deprivation of life is not absolute. Means life can be deprived of an individual if the due process of law is adopted, is followed. Your liberty is not absolute. Right to liberty is not absolute. Your liberty can be deprived of if the process given by law is adopted. Right to property. Your property cannot be deprived. This is not the fact. Your property you can be deprived of your property if the state adopts due process of law. See, for example, right to life and right to and the imposition of death sentence. Means, if the accused person is proved to have committed an offense which is made punishable to the death sentence. Death sentence. And in the course of trial, sufficient cogent and corroborative evidence have been brought on record by the prosecution. And by placing reliance on the testimony of the witnesses, court come to the conclusion that this is the fit case to impose death sentence to the accused person for commission of this and this offense. Then there is a process laid down to execute that death sentence. When such a process is adopted for execution of the death sentence, then question of deprivation of right to life doesn't arise. Why? Because it comes due process of law. Right to liberty means if any person alleged to have committed a cognizable offense, information is given to the police, then the police has got every right by the procedural law, from the procedural law, to conduct arrest of the accused person. In such a case, a accused person cannot say that my right to liberty has been deprived of. No. Why? Because when the police have got the information regarding, credible information regarding commission of cognizable offense, then it becomes their statutory responsibility or statutory duty to conduct arrest of the accused person. For what purpose? For the purpose of investigation. For the purpose of investigation. Another point is right to property. Right to property is no doubt the human rights. But when the property is concentrated in the hands of few and larger public is without property, then the socialism stands that the property must be distributed in those who don't have the property. The best example I would like to quote here that ceiling on holdings and the tenancy rights. In the course, as a result of effective implementation of these two laws, in Maharashtra particularly, thousands of landless people got the benefit and they became the, what you call, family holders, landholders. Second is right to property. When the property is required for public interest, namely a building of or constructing the dams, roads, etc., then the property is acquired by the government by adopting due process of law. In the year 2013, the Government of India has enacted the new Land Acquisition Act, and thereby the strict and comprehensive procedure has been laid down for acquisition of the land for the public purposes. And there is a mechanism erected that the special acquisition officer, a person who is not below the rank of deputy collector, is the land acquisition officer, and he conducts all the things. The decision which is taken by that authority is called as award, and that award is nothing but the decree as if it is drawn by the civil code, and therefore the appeal is referred before the district court and not before the civil court. So, friends, restrictions have been restrictions were put by the Bill of Rights in America. Now, French Revolution came. We'll now look at the French Revolution in 1789. You would be knowing that due to the aristocratic atrocious behavior, atrocious administration of the king, the French Revolution was taken place. Abolition of monarchy and establishment of French Republic. French Republic means the government of the people, government by the people, and government for the people. It is called as republic. Monarchy means abolition of the rule of king or queen. The head of the nation cannot become who got birth in the mother's womb, or from the mother's womb, who had the personality of queen. No. A person who becomes the head of the nation, who is chosen by the public at large by of casting vote. The basic principle of basic code motto of the French Revolution was all men are born free, they remain free, and they have equal rights. कोई भी आदमी गुलाम के तौर पे पैदा नहीं होता, वो फ्री है, कोई गुलाम नहीं, उसको फ्री मीन आजाद, वो आजाद रहता है और उसको इक्वल अधिकार है, मतलब इक्वल राइट्स है। ये बेसिक कोड जो है उसके आधार पर फ्रेंच रिवॉल्यूशन हुआ और आजादी प्राप्त हुई और रिपब्लिक स्टेट बोल के इस्टेब्लिश हुआ। डिक्लेरेशन गारंटीज द राइट्स ऑफ लिबर्टी, राइट्स ऑफ प्रॉपर्टी, सिक्योरिटी एंड रेजिस्टेंस टू ऑपरेशन। राइट टू लिबर्टी means liberty of thought, liberty of moving from one place to the other place, faith, belief, etc. Property means legitimate property acquired through legitimate ways and means, not the property to be occupied, to be possessed, which has been got through illegitimate or illegal ways and means. No. Right to security, सुरक्षित का अधिकार, and resistance to oppression means the authoritative, atrocious, oppressive administration of the state, उनको रेजिस्ट करने का अधिकार ये फ्रेंच रिवॉल्यूशन ने दिया। मीन्स द फ्रेंच रिवॉल्यूशन गारंटीज राइट टू लिबर्टी में ये इंडिविजुअल लिबर्टी है, प्रॉपर्टी संपत्ति का अधिकार है, सिक्योरिटी में सुरक्षा का अधिकार है, और ऑपरेशन के खिलाफ प्रतिकार करने का अधिकार या उसकी गारंटी फ्रेंच रिवॉल्यूशन 1789 देती है। ये ह्यूमन एग्जिस्टेंस के लिए काफी जरूरी है। अगर राइट टू लिबर्टी नहीं है, राइट टू प्रॉपर्टी नहीं है, राइट टू सिक्योरिटी नहीं है, या राइट टू रेजिस्ट द ऑपरेशन अगर नहीं है, नो वन कैन survive as a human being. Merely to get birth as a human being is one thing. It is one thing. But to survive, to enjoy the human life as a human life, they require to have guarantees of liberty, property, security, and resistance to the operation of the state to the individual is important, and then only a person who born as a human being can enjoy the human life as a human life. Another historical development took place for as an important step of evolution of the human rights, that is the first Geneva Convention, 1864. This convention was attended by 16 European countries and several American countries at the invitation of Swiss Federal Council. This document provided for care to wounded soldiers. Friends, in this particular period, meaning in 19th century, quite frequently wars were being taken place. In between the countries, in between different kings, for fulfilling the lust of power. And therefore, soldiers, in the course of fighting battle, were getting wounded, injured. But the soldiers were not given any right to ask for any proper treatment, care, whenever they get injured. The cases were quite rampant. And therefore, the Geneva Convention has taken care of to give proper attention towards the demands of the injured or wounded soldier, so that they would get proper care and treatment and get cured thoroughly, so that they would lead their remaining life properly. The main principle was laid down in the convention and maintained later to extend care without discrimination to wounded and sick soldiers. Keep in mind, again their question came that discrimination was done, experienced, while extending care, cooperation, treatment to the injured, sick, or wounded soldiers. By whom? By the state, or by the state machinery. And therefore, again, there was a care taken by the Geneva Convention that the care must be taken, treatment must be given to the wounded or sick soldiers, injured soldiers, without any discrimination on the basis of color, on the basis of religion, on the basis of race, nothing. Every soldier must be treated equally. If he suffers from any of the injury, if he sustains any of the injury, then in the fair way, in the fair manner, treatment must be given, so that he would get recovered properly. Friends, you must be knowing that after First World War, League of Nations was established, but due to inefficient functioning of the League of Nations, Second World War took place. And the Second World War began in the year 1939 and came to an end or culminated in the year 1944. Friends, the Second World War has resulted into huge destruction of property and of mankind. प्रॉपर्टी की क्षति, संपत्ति की हानि और मनुष्य की हानि बहुत बड़े पैमाने पे सेकंड वर्ल्ड वॉर में हुई। बर्बादी, तबाही, तबाही हासिल कुछ भी नहीं। यू मस्ट बी रिमेंबरिंग दैट by bombing on Hiroshima and Nagasaki, two cities of the Japan country, the full stop was given to the Second World War. These bombs were atom bombs, which resulted into huge destruction of the property and mankind, not to that generation, but to the upcoming generation as well. So, considering the adverse consequences, the what you call bad consequences of the war and use of the arms and ammunitions, the 50 nations met in San Francisco in the 1945, and America, Russia, China, Great Britain, France, the country, Russia, the country were at forefront, and they wanted to have such a international organization which would be able to protect the upcoming generation from the war and promote the peace and tranquility of the whole world. And therefore, the United Nations organization was established on 24th of October 1945. We the peoples of the United Nations are determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind. So this was the objective behind establishment of the United Nations organization. Earlier, there were few countries as a member of the United Nations organization, and now the number of member states have gone to 152 states or countries, and 5 are the permanent member of the United Nations organization. United Nations organization has been entrusted with a responsibility to maintain the world peace and avoid the war and provide the peace to the upcoming generation. Friends, though the United Nations was established, having its 5 principal organs, namely General Assembly, then Economic and Trustworthy Council, Social and Educational Council, the Secretariat, and International Court of Justice, Trusteeship and Beneficial Council, Security Council, 6 organs. Secretary General is also there. But some incidents have been witnessed by the world that for one or the other reasons, the wars are fought and some types of threats are being posed to the international peace. Another example which would be referred as the step of evaluation of the human rights, that is Nuremberg trials 1946. Certain German Nazis were tried for causing most barbarous and inhuman atrocities committed on Jews. It was treated as crime against humanity. And in this trial, it was assumed that human rights are valid by themselves, and these are above the law of any nation. Violation of them treated as crimes against humanity. Nazi, you must be remembering the rule of Hitler in the Germany, who created hatred against the Jews to such a way that, so far as published data is concerned, 70 lakhs Jews were killed in inhuman way. So this was nothing but massive violation of human rights. Friends, in order to propagate the concept of human rights, the United Nations organization, has placed one resolution on its floor, and that is called as Universal Declaration of Human Rights, 1948. This bill was brought on the floor of the General Assembly of the United Nations Organization, was under the dynamic leadership of Eleanor Roosevelt, and the draft was prepared by it. And it covers various types of human rights of an individual, and therefore this UDHR, this Universal Declaration of Human Rights 1948, is referred to as Magna Carta for all mankind. It was adopted by the General Assembly of the United Nations Organization on 10th December 1948. Therefore, in memory of this date, the 10th December is celebrated as the World Human Rights Day. जिस दिन means 10th December 1948 को ये यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट्स जब अडॉप्ट किया गया, पारित किया गया यूनो द्वारा, उस 10 दिसंबर को दुनिया भर में मानवाधिकार दिन, ह्यूमन राइट्स डे के तौर पे मनाया जाता है। Article 1 of this Article 1 of this UDHR provides that all human beings are born free and equal in dignity and rights. Born free मतलब सब जो मनुष्य प्राणी जो है वो आजाद पैदा होते हैं, उनको डिग्निटी और राइट्स के तौर पर इक्वालिटी है। कोई ऊंच नहीं, कोई नीच नहीं, कोई बड़ा नहीं, कोई छोटा नहीं, कोई गुलाम नहीं, कोई मालिक नहीं, all are equal. 30 articles of UDHR have become the part of the constitution of democratic country, including Indian constitution. सेकंड सेशन का जो पार्ट है उसमें मैं ये कंपैरिजन आपको तफसील से बताऊंगा। इन डिटेल आई विल डील विथ द कंपैरिजन बिटवीन द प्रोविजंस ऑफ द यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट्स एंड द provisions contained in Part 3rd of the Constitution of India, which provides for the fundamental rights, how they are closely interrelated with each other. And by this way, the framers of the Constitution of India have taken care of to protect the basic inalienable human rights of the people of India. So friend, now let us turn towards the another important concept, that is International Bill of Rights. As we have seen that the Universal Declaration of Human Rights have taken care of to give all rights, basic rights as a human rights to all citizens of member states or of the world, but it bears no force of law. And therefore, the United Nations Human Rights Commission had a task to create a body of international human rights law to enforce the UDHR. Means the United Nations Human Rights Commission was given the power, or it was given jurisdiction to enforce the human rights. Hence, the United Nations Human Rights Commission produced ICCPR, means International Covenant on Civil and Political Rights, 1960s. And ICESCR means International Covenant on Economic, Social and Cultural Rights. In the year 1976, both became international. Means initially, both the covenants were made in the 1966. But to get the force of law, it took again 10 years. UDHR, means Universal Declaration of Human Rights, together with these two, means ICCPR and ICESCR, known as International Bill of Human Rights. Friends, ICCPR and ICESCR are different because ICCPR are civil and political rights which are enforceable by law, and ICESCR means economic, social and cultural rights. These are not enforceable by law as if they are the fundamental rights. No. So this is what is the distinction or difference between these two. But together they are all civil and political rights as well as education, economic, social, and cultural rights are nothing but International Bill of Rights. International Bill of Rights. Friends, in this way, slowly and steadily, the human rights have been evolved in the world, and democratic countries, including India, have accepted it. So the concept of human rights, what is this all about? Human rights are those rights which an individual is entitled by virtue of his status as a human being. Human rights means जो मनुष्य प्राणी के अलावा अदर और भी जो प्राणी है वो अब अपने नेचुरल स्टाइल से जो जीते हैं, मनुष्य प्राणी का जीने का तरीका, रहने का तरीका अलग है। तो इसीलिए मनुष्य प्राणी के हैसियत से जीने के लिए जो चीजें जरूरी है उसको ह्यूमन राइट्स कहा जाता है। और ह्यूमन राइट्स का जो कंसेप्ट है, संकल्पना, वो ह्यूमन बीइंग को ये सब अधिकार प्राप्त करने के लिए अधिकार प्राप्त कर देता है। Civil, political, social, economic rights are dependent on an individual status as a citizen of particular country. See, civil rights, political rights, social rights, economic rights are to be enjoyed with by a citizen based on the citizenship acquired by him or her of that particular country. See, for example, इंडिया में अगर फॉरेन कंट्री में से कोई आता है और वो चाहता है कि मैं इंडियन सिटीजन की तरह मतदान का अधिकार प्राप्त करूं, अडल्ट फ्रांचाइज, वो हो नहीं सकता। क्यों? कि ये जो अधिकार है ये इंडियन सिटीजन को ही दिया गया है। इसीलिए सिटीजनशिप इज वेरी इंपॉर्टेंट। Citizenship of particular country is very important. Unless and until citizenship is not acquired, the civil, political, social, economic rights cannot be enjoyed with in that particular country. In that particular country. Now, let us turn towards another segment, that is importance of human rights. Friends, how significant role is being played by human rights? So human rights are the stepping stones for development, happiness, and peace for the human race. See, if human rights are not given, human rights are withdrawn from the life of human being, the human being cannot be developed, cannot have happiness and peace. So therefore, human rights are being considered as stepping stones for the development, happiness, and peace of human race. Another is, it allows mankind, means human being, the right to live with dignity. Dignity. एक डिग्निटी प्राप्त होती है ह्यूमन बीइंग। नहीं तो कोई भी आ रहा, कुछ भी बोल रहा है, कुछ भी कह रहा है, ये नहीं हो सकता। कुछ भी भाषा या शब्द का इस्तेमाल कर रहा है, ये नहीं होता। डिग्निटी मीन्स एक प्रतिष्ठा, एक स्टेटस। अगर आपके प्रति कोई गलत शब्दों का इस्तेमाल करता है, आपकी छवि, आपकी जो इमेज है वो मतलब कमी करने के लिए या उसको डैमेज करने के लिए कोई गलत शब्दों का इस्तेमाल करता है, वो नहीं चलेगा। वाई? बिकॉज ह्यूमन राइट्स अलाउज द राइट टू लिव विद डिग्निटी, एक स्टेटस, एक प्रतिष्ठा के साथ जीने का अधिकार प्रदान करते हैं। इट प्रोवाइड्स an opportunity for development to weaker sections. Friend, in every society, I repeat, there are two sections. One is stronger, another is weaker. Privileged and underprivileged. Forward and backward. So, the concept of human rights provides opportunity of development to the weaker sections. मतलब ये वीकर सेक्शन जो है उनके पास में डेवलपमेंट का कोई सोर्स नहीं होता। They lack the resources and therefore they are weaker. They lack the capacity, therefore they are weaker. क्षमता त्यांच्या उनके पास भी नहीं होती, रिसोर्सेज उनके पास में नहीं होते, उसके वजह से डेवलपमेंट नहीं कर पाते। और जब उनको ह्यूमन बीइंग का स्टेटस दिया जाता है तो उनको ह्यूमन राइट्स प्रदान किए जाते हैं। जब ह्यूमन राइट्स प्रदान किए जाते हैं तो उनको ये अपॉर्चुनिटी मिलती है डेवलपमेंट करने की। एक एग्जांपल के तौर पे मैं आपको बताऊंगा कि वुमन फॉर सेंचुरीज टुगेदर were deprived of right to equality, right to freedom. But now, as they have got equal status, and opportunity, they are now proved themselves to be the efficient on each and every walk of life. महिलाओं को जब ऐसे बताया गया कि महिला पुरुषों के समान है, और जब पुरुषों के समान है तो उनको पुरुषों की जो अपॉर्चुनिटी है महिला को दी गई, और जब महिला को अपॉर्चुनिटी मिली तो उन्होंने खुद को इतना एफिशिएंट साबित कर दिया कि वो कभी भी कुछ भी पुरुषों से कम नहीं है। Another importance of the human rights is that stability in society and government. जब सब ह्यूमन बीइंग को इक्वालिटी और फ्रीडम दिया जाता है तो सब जो है तो खुद को जिम्मेदार समझकर एक समाज में स्टेबिलिटी प्रदान करने के लिए कोशिश करते हैं, और नतीजे ऐसे निकलते हैं कि स्टेबल सोसाइटी एंड स्टेबल गवर्नमेंट। मान लो कि एक दत्ता दूसरे दत्ते से खुद को बड़ा समझ रहा है, ऊपर समझ रहा है, और दूसरा दत्ते को कम समझ रहा है, तो व्हाट वुड बी द प्रॉब्लम? दैट द डिफरेंट सेक्शन वुड नेवर अलाउ the other section to be in peace and stability. They will always cause disturbance. Always cause disturbance. हमेशा के लिए वो कोशिश करेंगे कि इनकी नींद हराम कैसे करना, इनको डिस्टर्ब कैसे रखना। तो इसीलिए हर एक को ह्यूमन राइट्स प्रदान करना ये समाज की स्टेबिलिटी और गवर्नमेंट की स्टेबिलिटी के लिए जरूरी है। So far as nature of human rights is concerned, there are differences of opinion. कुछ जो luminaries है, they are of the opinion that human rights are divine, moral, legal, customary, and outcome of social contract. But keep in mind, nature of human rights is universally acceptable. And therefore, what Article 1 of the Universal Declaration of Human Rights 1948 has underlined is that all human beings are born free and equal in dignity and rights. Means सभी मनुष्य प्राणी वो फ्री मुक्त पैदा होते हैं और उनको इक्वल डिग्निटी और अधिकार प्राप्त होते, प्रतिष्ठा और अधिकार इक्वली प्राप्त होते। कोई किसी को कम किसी को ज्यादा ऐसा नहीं, सभी को सही। एक को ज्यादा प्रतिष्ठा दूसरे को कम प्रतिष्ठा ऐसा नहीं होता है, सभी को समान प्रतिष्ठा होती है। So after accepting Universal Declaration of Human Rights, whatever earlier differences were there regarding nature of human rights, they all have been wiped out, and the narration of Article 1 of Universal Declaration of Human Rights has been accepted worldwide. Friends, no doubt, there is a theoretical orientation to this concept. Certain theorists, jurists, luminaries, they have looked at the concept of human rights from their own perspective. So far as natural law theory is concerned, it looks at human rights as human rights are gift of God. You must be knowing that the natural law theory is based on the underlying principle that law is a dictate of reason. Means जो नेचर को कबूल है वही लॉ है, जो नेचर कहता है वही लॉ है. So here the natural law theory says that human rights are gift of God, means भगवान ने देवी देनगी है. Human being is distinct and separate from the state. ये बहुत important. उनका ये भी कहना है कि स्टेट और ह्यूमन बीइंग आर सेपरेट, डिस्टिंक्ट, and therefore they say that all human beings are equal. Human rights are not dependent upon any authority. Means देखो कि human beings are equal, means all human beings, कोई ऊंचा नहीं, कोई नीचा नहीं, कोई बड़ा नहीं, कोई छोटा नहीं, कोई रिच नहीं, कोई गरीब नहीं, कोई अमीर नहीं, कोई गरीब नहीं, कोई पढ़ना नहीं, कोई अनपढ़, ऐसा कुछ भी नहीं, सब इक्वल है. जब वो मनुष्य प्राणी बोल के पैदा होते हैं तो सभी इक्वल है. And therefore, when they are equal, human rights जो उनको प्रदान होने वाले हैं, it is not depending upon any authority. अथॉरिटी के ऊपर डिपेंड और निर्भर नहीं होते. वो जब उन्होंने जन्म लिया है वैसे ही उनको प्राप्त होते हैं। ह्यूमन राइट्स आर नेचुरल, और वो कहते हैं कि ये नेचुरल है, स्वाभाविक है, निसर्ग जो जीने के लिए चाहिए, ये जो ह्यूमन बींग, वो सभी उनको मिलना जरूरी, therefore ह्यूमन राइट्स आर नेचुरल। On the other hand, positive theory is there. They say that every command of the state compels to behave to the subject. आपको मालूम होगा, you must be remembering the underlying principle of the positive theory, positivist thinker, that law is nothing but it is a command of sovereign. It is a command of sovereign. Sovereign means king, queen, dictator, or in present scenario, state. Though in the democratic country, the elected representative in capacity of minister or prime minister or the president, etc., they rule the country. They rule the country. But so from the perspective of positivist, they are the sovereign, and whatever they say is a command. And when they issue the command, that is binding on all the subjects, all the persons, all and with public at large. Another is legal realism theory. They say that human rights are part of the state policy. Means when state policy accord certain rights as a human right, certain rights as a human right, then only these rights can be considered as human right, otherwise not. Otherwise not. Legal realism. Another is idealistic or personality theory. This theory considers the right to personality as an absolute and supreme right. Right? Absolute and supreme right. सबसे ऊंचा और सर्वोत्कृष्ट, सबसे श्रेष्ठ. And social welfare theory, rights are the tool to bring about social change, joint ownership on all means of production. While discussing about the concept of human rights, I have touched to the concept of socialism. The state socialism is the base of state welfare theory. State socialism stands for the cause that distribution of the property, joint ownership, distribution of the resources, means concentration of the resources or concentration of the property in the hands of few is detrimental to maintain the social peace, social harmony, and therefore they stands for the demand that the resources, property must be distributed among the all members of the society. And same is the case of the human rights, that the human rights must be given equally to all human beings. Then theory of fundamental rights. Human rights are fundamental rights and they require no sanction from the state. Keep in mind, fundamental rights means those rights which are essential to live or to enjoy life as a human life. Take example of the Indian Constitution. Right to equality, right to freedom, right against exploitation, educational culture rights, right to religion, and right to read. These are the six various types of rights covered under Part 3 of the Constitution of India. They all are recognized. They all are considered as the fundamental rights. And therefore, the fundamental rights are those rights they require no sanction from the state. उनको sanction की जरूरत नहीं है. Friends, in addition to the theories of human rights, we will now turn toward the international instruments on human rights. The first and foremost I would like to refer to here is the International Covenant on Civil and Political Rights, 1966. It is divided into 6 parts and consisting of 53 articles. 53 articles. Right of self-discrimination, determination, political status, and pursue economic, social, and cultural development. Respect individuals. So, these are the core concepts of the International Covenant on Civil and Political Rights. If we compare it with the Constitution of India, then whatever provisions covered under Part 3, under the title of Fundamental Rights, from Article 12 to Article 35 of the Constitution of India, whatever rights are there covered, these all rights are nothing but the civil and political rights. Another international instruments on human rights is International Covenant on Economic, Social, and Cultural Rights, 1966. This instrument consists of 31 articles. It came into force on 3rd January 1976, and third one is International Covenant on Economic and Regional Development Right, 1966, and last one is CEDAW, which is in stricter sense called as Convention on the Elimination of all forms of discrimination against women. Friends, in whole world, if we look at the woman women are considered as secondary human being. As in majority of the countries, the patriarchy was accepted. As a adverse impact of patriarchy, the woman section, woman as a class, was considered as secondary human being. And when women were considered as the secondary human being, they were subject matter of discrimination. Their discrimination was of such a nature that the women were not even considered as human beings. In some of the societies, women were considered simply as the goods or commodities. So, it was indeed inhuman. It was indeed injustice. And therefore, the United Nations Organization had brought a proposal of Convention on elimination of all forms of discrimination against women. As women were deprived on all walks of human life. All walks of human life. This has proved to be the milestone in advancement, development, empowerment of the woman of whole world. Friend, what is the present generation enjoying? Means present generation woman enjoying the right. This is everything because of this convention. Otherwise, women in almost all society of the world were subject matter of discrimination and deprivation. If we take the case of our country, India, right to succession, right to inheritance was not given. If a woman who is born, she ceases to be a member, born in the family, she ceases to be a member of their family the moment she get married. She get married. She is bound to change her surname. She is bound to delete the name of her father, who she had before her marriage. She is bound to carry the identity of her father. In order to consider the Hindu woman eligible for right to inheritance vis-a-vis succession to the property of the father, year 2005 came. In the year 2005, there were necessary amendments made in Section 5 and Section 6 of the Hindu Succession Act 1956. So friends, it is the milestone to wipe out or eliminate the discrimination and deprivation of against the woman, that is none other than the Convention on Elimination of all forms of discrimination against women. So friends,
Sir, I think it is 4:30. So if you want, you can take a break and let the participant also take break. It's as per your convenience.
Yeah, no problem. Right, I was just pronouncing that. We will take a pause, a break, and we'll meet again after 10 minutes.
Yes.
Thank you so much.
Thank you. Thank you. So participants remain connected in this meeting, but we will have a 10-15 minute tea break.
Okay, thank you, ma'am.
Yes. Shall I start now?
Yes, sir. Yes.
Okay. So now, sir, how many of the participants have joined? 13. Okay. Say,
Yes, sir.
should I start? शुरू करना है?
Yes, sir.
Okay.
Yes, sir.
Okay.
Yes, sir. शुरू करो.
Yes. Thank you. See, what we have seen? This everything about the historical development of the human rights in the world. So now we will have a discussion about the reflection of the human rights concepts in the provision of the Constitution of India. Friends, at the cost of sacrifice of life, luxuries, comforts of thousands of patriots, we have got independence. We have got an independence. And in order to have real food, real fruits enjoyed by all the people of this country, we were in need to have the Constitution, which would give us stable and responsible government, which would be committed to development of the common mass. Common mass. So therefore, you are knowing that the Constituent Assembly was established. It was consisting of the elected members from the public, and these all members have again became the members of the respective committees. So far as the Constituent Assembly is concerned, it was headed by Dr. Rajendra Prasad as the chairperson. And the drafting committee is concerned, it was headed by Dr. Babasaheb Ambedkar as a chairperson. So after taking lots of pains, the Constitution of India was drafted, keeping in view that every sections of the society should be satisfied with the provisions of the Constitution. He must feel himself to be safe, secured, dignified. And therefore, the preamble of the Constitution of India begins with the wording that we, the people of India, having solemnly resolves to constitute India into sovereign, secular, socialist, democratic, and republic. These are the 5 objectives to be achieved by way of the execution and implementation of the provisions of the Constitution. In addition to this Constitution assures, this Constitution ensures to have justice, liberty, equality, and fraternity. So far as opportunity, equality is concerned, equality of opportunity and of status. Equality of an opportunity and of status. म्हणजे संधीची आणि दर्जाची समानता. कोणाला? सगळ्यांना. So far as fraternity is concerned, because you know, in Indian society, there were several inhuman practices in existence, in prevalence, and due to which concept of fraternity was questioned. वेगवेगळे अलग अलग आधार पे समाज में डिस्क्रिमिनेशन मौजूद था, वैसी प्रैक्टिसेस मौजूद थी. Most worst practice was untouchability. Most worst. But Constitution of India stands for elimination of the untouchability. The preamble says that fraternity means assuring the dignity of individual and unity and integrity of the nation. Dignified life to the individual is nothing but recognition to an individual as a human being. कहाँ पे पैदा हो, कौन सी जात से है, कौन से धर्म से है, कौन से ये स्त्री है या पुरुष है, कोई मायने नहीं रखता. Assuring the dignity to the individual, उसको डिग्निटी है, डिग्निफाइड लाइफ, ये ह्यूमन एग्जिस्टेंस है. सो ये कॉन्स्टिट्यूशन ऑफ इंडिया. फ्रेंड्स, when we look at the provisions of the Constitution of India, which are befitting to the provisions of the Universal Declaration of Human Rights 1948, जो यूनाइटेड नेशन ऑर्गेनाइजेशन ने रिजॉल्व किया था, जिसके चलते हम 10 दिसंबर जो है उसको ह्यूमन राइट्स डे सेलिब्रेट करते हैं. तो उसके प्रोविजन और इंडियन कॉन्स्टिट्यूशन के प्रोविजन कौन से हद तक और कैसे मिलती जुलती है, इसका भी हम तफसील से विचार कर ये लेंगे, चर्चा करेंगे. सो नाउ when we look at as to what are the human rights found to be in existence or found to be available in the Constitution of India, then one has to refer to part 3rd of the Constitution of India. The part 3rd of the Constitution of India is called as the Magna Carta of India. जो मैग्ना कार्टा यूनाइटेड किंगडम में हमने देखा था इन 13th सेंचुरी, बिल ऑफ राइट जो देखा था, तो इसको विजय रामचंद्र नाम के एक जूरिस्ट है, उन्होंने पार्ट 3rd ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया इज कॉल्ड एज द मैग्ना कार्टा ऑफ द इंडिया. सो व्हाट आर द राइट्स which are given to the Indians with an objective to protect the human existence of the people. And these all are called as fundamental rights. These all are called as fundamental rights. मैं दोहराता हूं, I'll repeat. Which are they? Right to equality, समानता अधिकार, right to equality. Second, right to freedom, स्वतंत्रता है, right to freedom. Right against exploitation, educational and cultural right, right to religion, and last, right to constitutional remedies, means right to writs. So now, so far as right to equality, right to freedom, right to life and personal liberty, right against exploitation, right to religion, educational and cultural rights, these are all these all are the human rights. So how come these all are to be called as the human rights? The reason behind is that the human rights which were recognized as the human rights by The Universal Declaration of Human Rights 1948. The Article 2 of UDHR, means Universal Declaration of Human Rights, is similar to Article 21 of the Constitution of India. Similarness means how? Article 21 of the Constitution of India says that right to life and personal liberty. No one, the wording of this article is, no one shall be deprived of his personal life and liberty unless by adopting the procedure established by law. Established by law. Life and liberty, right to life and personal liberty is a fundamental right. Vis-a-vis, it is the basic human rights given. Basic human rights given to the Indian people, to the Indians. Another example I would like to quote that the Constitution of India provides another human rights to the individuals, that is Article 14, right to equality, equal protection of law and equality before law. Equal pay, right to equal pay for equal work. No discrimination on the basis of sex, race, place of birth, religion, etc. Equality. So this Article 14 is similar to Article 7 of Article 14 of the Constitution of India is similar to Article 7 of the Universal Declaration of Human Rights 1948, which was passed by the United Nations Organization. Another example I would like to quote that Article 32 and Article 22 to 226 of the Constitution of India, both the articles, Article 32 and 226, provides that if the fundamental rights of the citizen of India are violated, infringed, then the victim is empowered, is entitled to go and knock the door of the High Court and of the Supreme. So far as 226, Article 226 is concerned, the victim, in case of violation of fundamental right, may go to the High Court and seek the appropriate remedies. What are the appropriate remedies? In Article 32, there are 5 remedies provided. Habeas corpus, mandamus, prohibition, certiorari, and quo warranto. The remedies are varied depending on the violation of fundamental right. High Court is empowered to go to issue the appropriate remedy. Friend, how it is human right, or how this right is to be called as human right? The reason is this provision is similar to Article 8 of the Universal Declaration of Human Rights 1948. 1948. So this Article 8 provides a base to call Article 32 and Article 226 of the Constitution of India as basic human right. As basic human right. Another example, I quote, that is none other than Article 19. of the Constitution of India. Earlier, there were 7 freedoms guaranteed under this article by the Constitution of India, and now there are 6, as right to property has been deleted from it. And therefore, only now 6 freedoms are there. Freedom of speech and expression, freedom of movement, freedom of assembly, freedom to trade and business, trade and business, association, freedom of association. In this way, there are certain golden freedoms made available to be enjoyed with certain restrictions by the citizen of India. If these freedoms are not given, if these freedoms are withdrawn from the life of an individual, the life of an individual becomes life of other animals. Why? Because freedom of speech is not there given. Then you will be down. आपको जब कुछ एक्सप्रेस करने का, कुछ बयान करने का अधिकार अगर नहीं दिया जाता है, तो आपको आपका मुंह जो तो बंद रखना है. आपको नेचर ने, स्वभाव ने वाचा देने के बावजूद भी आप क्या होते हैं, आप डम हो जाते हैं. तो ये बहुत जरूरी है, ये बहुत जरूरी है. मूवमेंट, असेंबल, एसोसिएशन, ट्रेड एंड बिजनेस, ये सब चीजें जो है तो ह्यूमन एग्जिस्टेंस बरकरार रखने के लिए जरूरी है. उसकी वजह से ये फंडामेंटल राइट जो है तो ये ह्यूमन राइट्स अगर है तो कैसा है, आर्टिकल 13(1) ऑफ द यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट्स प्रोवाइड्स अ बेस. ये जो है इट इज सिमिलर टू आर्टिकल 13 of the Universal Declaration of Human Rights. Another provision is, okay, I'll again add some things, that Article 19 is not the absolute right, keep in mind. It is to be enjoyed with certain restrictions. ये जो अधिकार, स्वतंत्र के अधिकार, फ्रीडम्स जो दिए हैं, ये एब्सोल्यूट नहीं है. इसीलिए एब्सोल्यूट नहीं है कि अगर आपको एब्सोल्यूट राइट अगर दिया जाता तो आप उसका इस्तेमाल करके दूसरों को तकलीफ पहुंचा सकते, दूसरों को परेशानी दे सकते. वैसा नहीं होना चाहिए. एक का अधिकार दूसरे को परेशानी में तब्दील नहीं हो सकता. एक का अधिकार दूसरों के परेशानी में तब्दील नहीं हो सकता. उसी की वजह से some precautions have been taken by the framers of the Constitution, and certain restrictions on the enjoyment and use of the freedoms are there provided. Within the frame of that restrictions, all the freedoms are available to enjoy by the Indian. The base for calling it as the human rights is Article 13 of the Universal Declaration of Human Rights. Or another example I would like to quote is Article 25 of the Constitution of India is similar to Article 18. Article 25 of the Constitution of India provides educational and cultural rights. 25, 26, 27, 28. Educational and cultural rights to establish and run the education institutions, to protect your culture. ये human rights है. Why it is to be called as human rights? The reason is that there is a corresponding provision found in the Universal Declaration of Human Rights provided under Article 18. Provided under Article 18. So the Article 18 of the Universal Declaration of Human Rights provide a base to call Article 25 of the Constitution of India as the human rights. Means these 6 respective articles covered under Part 3rd of the Constitution of India do have close similarity, close intersection with the respective provisions of the Universal Declaration of Human Rights. And therefore, one has to say, or one can say, that the fundamental rights provided under respective provisions are nothing but the basic human rights given by the Constitution of India to its citizens. To its citizens. Friends, now we look at the cases of violation of human rights in our country. Means factual scenario. How human rights are taken care of by government agencies or by private individuals in our country. So, to maintain law and order, public peace and tranquility is the sole responsibility of the police. And therefore, certain power to exercise coercive measures have been given to them. Means police can exercise coercive measures to combat the anti-social element activities and maintain the law and order in the society. But what happened? Directly or indirectly, we carry the legacy of British rule, police state. And in certain cases, the powers conferred upon by law, conferred upon the police by law, are excessively exercised. In result, what happened? Violation of massive human rights. I have certain figures that Asian Center for Human Rights has estimated that from the year 2002 to 2008, over 4 persons per day died in the police custody, with hundreds of those deaths due to police torture. Friends, this is the reason why Supreme Court has given decision quite repetitive in respective matters that the powers to use excessive or coercive measures by the police have been curtailed. In certain cases, strict adverse remarks have been passed by the Supreme Court against the police. Another data I would like to put forth, that is, as per report of Institute of Correctional Administration in Punjab, it says that 50% of police officers use physical and mental abuse of the prisoners. So, when police uses such a abuse, it is violation of the human rights. In addition to police violation of the human rights by the police, there are certain cases of violation of human rights in or through religious violence. Friends, when India became independent, it became independent with two separate independent nations. One India, another Pakistan. I don't want to go into the root causes of creation of this country, Pakistan. But when it created, it has resulted into religious violence. Friends, there was massive killing of people in Kolkata. Naukhali, we must be knowing, Hindu-Muslim riots. Muslim-Sikh riots. Thousands of people were killed in the religious violence. When people have been killed, it is massive violation of the human rights. In India, when there was the assassination of the then Prime Minister late Srimati Indira Gandhi by her bodyguards, by virtue of the reason they were from Sikh community, there was hatred created against the Sikh community, which resulted into a riot, communal riot, and within 4 days, 2006, were massacred. Again, it is a proved fact that some of the leaders, political leaders, were found to be guilty and convicted for this killing. In the year 1992, Bombay riot. In the year 2002, Gujarat riot, Hindu-Muslims. Gujarat riot ended with 1,044 deaths, 223 missing cases, 2,500 injured, 790 Muslims and 254 Hindus. But unofficial figure says that the death is not only restricted to or limited to 1044, but it is up to 2000 deaths. So friends, in this way, the violation of human rights is being happened in our country. There are another example that Assam Human Rights Watch reports that the journalists and human rights activists are arrested for falsely reporting on human rights abuse. It is fourth state in abusing human rights. Assam, you must be knowing, it is one of the states of the Seven Sisters of Northern East India. This country, this particular state has become restless on ethnic issue, language issue, and that ethnic hatred has again given a rise to create Mizoram as a separate state. There always happens violation of the human rights. Punjab, the power struggle movement, which was started by the then religious leader Saint Bidranwale, that to have Punjab as an independent country, and in order to sabotage this particular struggle, Blue Star operation was initiated by the government of India, and this operation was inevitable. This is what is the argument of the government, but this operation has resulted into deaths of civilians, militants, and soldiers. The figure goes 50,000 persons were cremated unceremoniously by the police. Means no official record of their residence and all the things was made available. Friends, Jammu and Kashmir is the state which is, after independence, posed to be or proved to be restless in terms of maintaining peace and tranquility for one of the other reasons. There are certain militant groups, they have their own demands. Considering their demand as anti-national, Government of India has deployed forces, armed forces, paramilitary forces there. Deployment of such a huge number of army personnels, the Office of High Commissioner for Human Rights shown its concern about the civilian casualties and restrictions on the freedom of assembly and expression in Indian administered Kashmir. Friends, in the year 1996, Human Rights Watch is a NGO which exclusively work for human rights, protection and propagation. This Human Rights Watch accuses to the military and paramilitary forces for serious human rights violation in the state Kashmir. The incidents have been quoted, namely rape, disappearances of human rights organizations in Kashmir, by police and the army. In the first 10 months of the year 2017, 14 militant attacks are reported in state of Jammu and Kashmir, in which 184 persons were killed. In Badgam, army used bystander to evacuate security and election staff. Again, there is a huge demand from the public that to review the Armed Force Special Power Act, because it is said or it is argued that the Armed Force Special Powers Act has given enormous uncontrolled power to the armed forces, and by exercising such a powers, it is misused. In result, there happens massive violation of the human rights for decades together, and therefore civilian demands to withdraw or to review this Armed Force Special Powers Act. But still, government has not done so. Government is of the firm opinion that in order to maintain peace and tranquility, law and order in the disturbed or some notorious region, deployment of armed forces and paramilitary forces are required, and such types of powers are to be given to them. By the end of November 2017, the government imposed 27 internet shutdown in the state of Jammu and Kashmir. Friends, due to rampant spread of network of internet, the speed of communication has been enormously enhanced, and therefore the message can be speedily passed from one place to the another place. So in order to stop the communication, the internet is to be stuck down. So in the state of Jammu and Kashmir particularly, it is done. Friends, after 2018, the necessary amendment has been carried out in the Constitution of India, and the special status which was accorded to the state of Jammu and Kashmir has been withdrawn, and now it has been divided into two parts, Ladakh and Jammu and Kashmir. And now these three are under the control of the central government, as they have been declared as the union territories. Now, it is claimed by the government that there is a peace established and people are now enjoying civil life quite properly. And now the incidents of violence and violation of the human rights are rarely reported. See, take the case of Punjab and Haryana. In the month of August 2017, 38 people were killed during the protest in Haryana and Punjab for supporting the Guru, spiritual Guru, who was convicted for committing rape on two female followers. So, it is always happened that a popular personality is prosecuted or arrested or etc. Their followers started protest, and in order to control such a protest, some force is being used by the police. But in this case, 38 people were killed. Therefore, it is to be referred as example of violation of the human rights in our country. Friends, take the case of Darjeeling. In Darjeeling, 8 persons were killed while protesting to have Bengali language compulsory in schools. In the month of June 2017, this has been reported. There is a dispute of the Darjeeling people and the rest and other parts of state of West Bengal. There the Darjeeling, the people, those who reside in Darjeeling Hills, they demand to have Darjeeling to be declared as a Gorkha land, separate state than the separate from the state of West Bengal, and therefore this contradiction has resulted into this protest and violation of the human rights. In Madhya Pradesh, in the month of June 2017, 5 farmers were shot-gunned by the police when they were protesting for fulfillment of their demand to have debt relief, and better price to their food grains. Another case in Mumbai city, that Manjula Shetty died in Mumbai prison after 6 prison staff beat and raped her. It is called as, in technical language, custodial rape or custodial death. Friends, Amnesty International is the London-based NGO which exclusively meant for the human rights protection and propagation. And there is another equal human rights voluntary organization, NGO, that is Human Rights Watch. They both have condemned human rights abuse in the state of Jammu and Kashmir, like disappearances of the people and torture of the public. The Armed Forces Special Power Act grants, as I already told you, that wide powers of arrest, to shoot, and to occupy and destroy the property of the individual by the military. And the exercise of these powers resulted into violation of the human rights. This is what is the counterclaim. Of the individual. Friends, violation of human rights is not only limited to the religion, religious violence, or the struggle between state and the public, but there are certain instances of caste-related issue which have been resulted into violation of human rights. The place where I'm addressing is called as Marathwada. In this Marathwada, from 1995 to 2014, from the year 1995 to the year 2014, the cases of caste-based atrocities, these are the cases which have been registered as per the provisions of the SC/ST Prevention of Atrocities Act 1989. The incidents have been of different kinds. namely abuse in filthy language, insulting, destruction of property, rape, outraging of modesty of woman, etc. And even attempt to commit murder, assault, and murder. From the year 1995, because the SC/ST Prevention of Atrocities Act 1989, though it was enacted, passed by the Indian Parliament in the year 1989, it became enforceable in the real sense and means from the year 1995. Why? Because in that year, the rules were framed by the government. So therefore, from this point onwards, when this act becomes practically implemented, the figures shows that 6,637 cases of atrocities. This is the figure of registered cases. It may also increase. Why? Because in certain cases, for one or the other reasons, victims don't go to the police station and dare to register the case. Another example I would like to tell you, that is Criminal Tribes Act 1871, which was replaced in 1952 as Habitual Offenders Act. Friends, undoubtedly, the Criminal Tribes Act 1871 was drafted, enacted, implemented by the British rule. In the British rule, certain tribes as a whole, this is great irony on part of human being, that was labeled as criminal tribe. Whenever any criminal act is happened, then the whole community is blamed that this act must have been committed by the members of that particular tribe, criminal tribe. But still, these tribes are targeted and indulged in prevention of anti-social act, and they are prosecuted and punished. Friends, as of reality, as of fact, आज भी अगर कहीं चोरी, लूटपाट जैसा अपराध होता है, तो पुलिस को ये लगता है कि यहाँ पारदी ट्राइब के जो लोग हैं वो कहाँ रहते उनको ढूंढो, हो सकता है इन्होंने ये किया हो. Why? Because this is the why such a tendency is there of the police, because of this act. Friends, in order to take care of the human rights of the scheduled caste and scheduled tribes, the government of India has taken care to establish the Scheduled Caste Commission, Scheduled Tribes Commission, as per the provision contemplated under Article 338 of the Constitution of India as independent legal entity. And this commission prepares and publishes every yearly report. As per the report which was published in the year 2017, 16 and 17, the cases of atrocities of violation of human rights of the members of scheduled castes and scheduled tribes, that is to the tune of 29,937 cases pending. So in this way, violation of human rights is there in our country. Most inhuman thing I would like to share, that still in our country, manual scavenging is in prevalence. On the one hand, we claim to have developed technologically. But still we do allow manual scanning. Means the human beings deployed to clean the waste, human etc. by the human. It is very inhuman. Friend, what happened? There is Prevention of Manual Scavenging Act 2013. But keep in mind, in the month of April and July 2018, 39 people died. Why? Because they've been trapped in toxic sewage lines as they were deployed to clean the sewage lines. See, another examples are there of the violation of human rights of tribal communities. The post-independence era is known for development. Post-independence era in India is called as development, era of development, or is known for development. Development means agricultural development. And for agricultural development, they are required to have water. And for storage of water, certain big dams were constructed. Take the best example of Sardar Sarovar. Narmada Valley project was inaugurated by the then Prime Minister Pandit Jawaharlal Nehru with the ambition that this dam would be an instrumental to bring about green revolution in the state of Madhya Pradesh, Gujarat and Maharashtra. And therefore, 30 dams were allowed to construct on the river Narmada. Indira Gandhi Dam and all others, Rajiv Gandhi Dam and all others. The last dam was Sardar Sarovar, which was argued to be beneficial to the state of Madhya Pradesh, Gujarat and Maharashtra. It was constructed. But when the demand from the beneficiaries came to increase the height of the wall of the dam, it was resisted by the activist, saying that the height of wall may result into this massive displacement of the tribal communities, those who stay in Satpura Jungle, Satpura Mountains. And for resisting the increase of height, there was Narmada Bachao Andolan established by Medha Patkar, and she fought the battle. But when the matter went to Supreme Court of India, her side was not taken into consideration positively. And after all, the height of the wall of that dam was allowed to increase in result. The capacity of water storage increased, which resulted expansion of the water. That expansion of water resulted compulsory displacement of the tribals. They lost their habitats, their houses, and in this way, it has become the sole cause of violation of human rights of the tribals. Friends, every year we read the news items that malnutrition of the children in our country. Most particularly, when we are from Maharashtra, the children from Melghat and children from Nandurbar district. Who are they? Why they have become the victim of malnutrition? They are the tribals, and they are the victims of the malnutrition because when they are in the mother's womb, they don't get appropriate percentage of ingredients, food ingredients, what they want for their proper development. They all are the children of the tribals. All are the children of the tribal. And as they are the victim of malnutrition, their right to life, right to liberty, the right to life, most particular right to life, is being questioned. And this is amounting to violation of the human rights. Take the case of violation of woman's right. There is independent organ established by the government of India, that is National Commission for Women. The National Commission for Women is the legal entity which is meant for women empowerment and protection of women at large. When we look at the data in the year 2016-17, the cases which were received of violation of women's right, it was 17,290. The majority of the cases, namely 5,404 pertaining to right to life with dignity. Right to live with dignity. Means dignified life was denied to the woman. 4,710 cases were pertaining to police apathy against women. And still, most ironically say that 2,255 dowry death cases. Means in this way, human rights of women are violated. Friends, women and girls should have access to abortion after rape, for which they had to go to the High Court. In 2017, Delhi and Chandigarh, when doctors denied to do so. So, the forceful sexual assault may sometimes give rise to the pregnancy, and that is not proper. And therefore, for abortion of that, the victims had to go to the High Court. So in the month of July 2018, Supreme Court has issued the directions that in case of offense made punishable under section 498A, if the arrest should not be made unless complaints are verified by family welfare bodies. It is widely argued that the married woman who goes to the police station and complains for cruelty of the conduct by her husband and his relatives are false, and therefore the complaints are discredited, not believed in. The credibility is lost in a result. The Supreme Court has given such a directions. Violation of Muslim minorities or other religious minorities. So there are rampant examples of attack on Muslims on the cause that they have sold, bought, or killed the cows for beef. They are made victims of case under law banning cow slaughter. There were 38 attacks on this cause on the Muslim people. In the course of that, 10 Muslims were killed. 15 Muslims were arrested by the MP police, Madhya Pradesh police, on the sedition, and for the reason that they were celebrating the cricket victory by Pakistan. According to Reporters Without Borders, India ranks 122nd worldwide in 2010, 114th in 2014, where the human rights and freedom of expression is violated. Article 19 provides freedom of speech and expression. It includes the right to seek information as well. And therefore, in the year 2005, RT Act was passed, and the earlier act, which was passed in the year 1923, Official Secrets Act, it has been replaced. Friends, in order to give proper information to the public, All India Radio was started by the government in the year 1975. But after 1990s, the private control on the media has been increased and selective information is being propagated to the public. Another burning issue, that is right of LGBT community. There is a sizable struggle of the LGBT community to have legal right to them to live together. In the year 2009, Delhi High Court had decriminalized sexual acts between consenting adults, laying down it is violative of Article 21, 14, and 15. And afterward, when the matter went to the Supreme Court of India, the Supreme Court has on 11th December 2013, homosexuality was criminalized. Again, in the year, most particularly date is 6th September 2018, the decriminalized homosexuality and banned discrimination based on sexual orientation. And therefore, in result, Section 377 of the old IPC, now it has been replaced by BNS, Bharatiya Nagrik Sanhita. It has been replaced by that. And this section has been replaced. Children's right. Friends, the 7-year-old boy murdered in private school in Haryana. This incident had disclosed child sexual abuse in the school, homes, and residential care facilities. Over 60 children died in public hospitals in Uttar Pradesh in August of 2018 as the private suppliers cut off oxygen supply due to non-payment. See, medical treatment ought to be given on top priority. But what happened in this particular case, the private supplier who was not paid by the government or the public hospital, he didn't supply oxygen. In result, 60 children died for not getting the appropriate percentage of oxygen required for their bodies or for their survivals. See, children education was frequently disrupted in areas facing conflict and protest. Friend, there is a popular amendment made in the Constitution of India, that is 86th Amendment, and early childhood care and education to all children up to 6 years. It has guaranteed the free and compulsory education to the children from the age of 6 to 14 years. In consonance with this particular provision, Right to Education Act 2009 has been enacted. And accordingly, right to education has been guaranteed to the children. Including this right is equally applicable to the private schools as well. See, when there is a clash between protesters and security forces in the state of Jammu and Kashmir, it results into closing of the schools and colleges, which results into violation of the human rights of the students. Now, Darjeeling, same case. When there is a conflict, the common life is disturbed, which result into disturbance of the human rights. In the month of October 2018, the Supreme Court laid down that sex with girl below the age of 18 years was unlawful regardless of whether she is married or not. Said exception of married girl was discriminatory, means consent is immaterial. Friends, there is a social group, means persons with disabilities. In April 2018, new mental health law was enacted, providing thereby mental and health care services for everyone and decriminalize the suicide. The Persons with Disabilities Equal Opportunity Protection of Rights and Full Participation Act 1995 has been enacted, and thereby their facial status is legally recognized, and they have been given facial privileges. You are well aware of the fact that Rohingya Muslims, they were flayed by Myanmar, and the Rohingya Muslims groups, they were on the water for months together, and several of them were died. Friends, so far as legal mechanism is concerned in our country, the Protection of Human Rights Act 1993 was enacted. This Act contains 43 sections. It came into existence on 28th of September 1993. This Act provides establishment of National Human Rights Commission, which was established on 12th October 1993. In addition to the National Commission for Human Rights, State Human Rights Commission are also allowed to be established at every state level. Section 3 of this Act empowers to inquire, investigate the matter of human rights violation, to undertake the research regarding human rights propagation, promotion, and violation. The complaint regarding incident took place before 1 year cannot be entertained. Complaint regarding matter is sub judice, or complaint which are vague. Such matters are not entertained by the Human Rights Commission. Friends, when it was established, the first chairperson was Justice Ranganath Mishra, who was retired Supreme Court Judge of India. एवढं आठवण झालं पाचच केलं 5 मिनिटं होईल. See, status of National Human Rights Commission, it has all the powers of the Supreme Court to try the suit under CPC. After inquiry, matter is forwarded to the concerned magistrate for further trial. If the matter is of criminal nature, the matter is forwarded by the commission to the magistrate court. In case of negligence of public servant, the commission is empowered to recommend to initiate necessary action against that public servant. Means one who flees for refugee to another country, especially from a religious or political commotion. There are sizable refugees staying in our country, more particularly from Tibet. After occupation of Tibet by China, thousands of Tibetan got shelter in our country. They are to be called as refugees. So in this way, the India is taking care of the human rights of the people. There is a sizable judicial activism shown by the Indian judiciary to protect the human rights of the people. As the Supreme Court has been empowered by the Constitution of India to issue appropriate writs, it has issued them from time to time. The first and foremost case is Husainara Khatun versus State of Bihar. Friends, in this particular case, the Supreme Court has said that free legal aid shall be given by the state to the person who is not capable to pay the fees of the advocate. Means free legal aid must be provided to. Nilavati Behra versus State of Orissa. In this case also, this is the fifth case which is to be called as a violation of human rights of an individual. In this particular case, there was a custodial death. Means a person who was taken by the police in the daylight was found to be dead. And her mother straightway filed a case against the police and matter went up to Supreme Court. In this case, the Honorable Supreme Court of India has given a judgment stating that the police should pay compensation to the mother of the deceased, as it was custodial death. Unikrishnan versus State of Tamil Nadu, in this case, right to education has been considered by the Supreme Court of India as a fundamental right, and therefore necessary amendment has been made in the Constitution of India and Article 21A has been inserted. DK Basu versus State of West Bengal, in this particular case, the Supreme Court of India, by exercising the constitutional powers, has laid down that at the time of arrest of the accused person, certain SOP must be followed. Number one, the police must be in the uniform, having their nameplate and buckle number. When they go to the accused person for arresting, the cause of arrest, grounds of arrest must be shown. After arrest of the accused person, necessary information of the arrest must be given to the relatives. Again, they must be given information that they have right to engage the advocate of their choice to fight the case. MC Mehta versus Union of India. MC Mehta is an advocate who was practicing lawyer in the Supreme Court of India, who filed more than 150 cases. Every case is PIL, meant for protection of environment. Friends, in this case, the Honorable Supreme Court of India has underlined the principle that uncontaminated environment is the right to life. right to life. Sunil Batra's case was a Delhi administration, means a person who was detained more than the period of imprisonment by the jail administration, he was released. Bandhuwa Mukti Morcha was Union of India. Child labor was banned by the Supreme Court. So friends, the Constitution of India has aptly dealt with the human rights of its own people. And if at all there is any case, then this is what is the mechanism that necessary complaints can be moved to the different machineries, and the necessary reliefs can be sought. So with this, I conclude. Thank you so much for your passionate listening, and coordinator for giving me an opportunity to address. Thank you so much.
Thank you, sir. Thank you for your enlightened sessions. Now I request vote of thanks from the participant whose number is scheduled for today's session.
Ma'am, I think roll number 12 is the turn
Yes,
to deliver vote of thanks.
roll number 12. Please
12.
Yes.
excuse.
Yes, madam. Okay.
Okay.
Yes, roll number 12.
1 minute, sir. Hello, good evening to everyone. On behalf of Dr. Baba Saheb Ambedkar Maratha University, Chhatrapati Sambhaji Nagar, UGC Malviya Mission Teacher Training Center, I have given now the vote of thanks to today's our guest lecturer, Dr. Pramod sir, who have given such a valuable guidance on human rights and constitutions. He has also given examples, and such examples are very informative, and such session are very informative. So thank you to today's our guest, Dr. Pramod sir, and thank you to everyone.
Thank you so much.
Thank you, sir. Nice
Thank you.
information.
Thank you very much.